What's going on? What's going on? What's going on? Let me see. Get a couple more people in here. Let's start. How's it going? Let me know if you have any particular questions before we get into it. What's going on, John? All right. Alright, well, I got a couple people in here. I'll start doing that. So, one thing most people probably aren't aware of is legalese. Legalese is something that it is entirely separate language. It's like an amalgamation of English, Old English, French, Latin, and maybe something else. It's got quite a number of terms from those different languages. It's also got a lot of mariners terms and shipping terms from the pirates, of course. That's why you hear different words like parlay and parlance, things like that, and betting and other things like that. Shipping, manifests, vessels, transportation. But specifically with the courts, yeah, it's definitely different. But specifically with the courts, it is, its own diverse, language for real. There's a lot of things that judges say that are not, sound like they're common speech, but they're not. One of the things there is, people have probably heard of different things, and to an extent, but realistically, it's like, when the judge asks you, okay, what is your name? Or give me your name. He's asking you to give the name for the record. So when you actually give your name, you're giving them the rights to your name. So, if you're not careful, then, so if the judge asks, give me your name, and like, no, why do you want, only if you, only if you, agree to give it back in kind, with for future return with my interest. So things like that. Or, say, do you understand? And be like, no, I don't understand. I'm aware of certain things, but then, yeah, there's things to be aware of in certain, another thing is saying that you have a middle name, or saying that, your name is first, middle, last. So they say, are you John Henry Doe? No. You could say John Doe. You could say Doe, John. You could say a bunch of things. You could say even John, just for, But if as soon as you say John Henry Doe, they know they got you. I did that before, and it did not go in my favor. There's so. Another thing too is when you're dealing in court, you have to say objection. If you don't say objection, they'll keep on going and acting like you consented to the whole thing. Yeah, it is in Old English, whereof, things like that. It is good to know those different words. Those are the Old English that, because that's actually proper English. What we speak today is garbled at best, a lot of times, technically speaking. Another thing, and another possible remedy that my associate has been telling me about is, like I said, I haven't tried it, but asking for a court interpreter. Because if they speak legalese, and they have admitted, judges have admitted, it's its own separate language, it's not English. So the only way you could do, is you need someone, a court interpreter. That's another way to go about it. I don't know. I haven't tried it. Like I said, you'd have to do that at your own risk. But it is something. They have openly admitted that it is definitely its own language. Yeah, cease and desist. That's a term that when somebody doesn't have the rights to do something, they have to. If that's a notice that you send out, or a notice even to give into the court, to cease some particular action. Null and void. Null and void are both things and places. They're not, the absence of, like, a nullity is or a null is. They talk about it in Marvel, but the void is a place that is not governed by normal laws. It's absent of laws, and it's also termed infinity and other things like that. But when you send something to the void via null and void, it sends that thing there. Performance means a couple of different things. One is a public show. The other one is the specific action or duty being done that is required under some type of agreement or contract or trust agreement. Even the court. The court is the paperwork, or wherever the officers of the court are. Well, generally speaking, the clerk and the notary are and the bailiff or sheriff are the officers of the court. The judge is just the trier of facts. So wherever the papers are, that's the court. So you got to be aware of that. Another thing is stepping into the bar. If you step past that bar, you're essentially barred from the living, and you're entering into the realm of the dead. So you step into there, you're in their realm, and now you're in their territory. Now they looked at you, as long as you, and especially when you haven't claimed the office of executor, they're looking at you like, you just stepped into their house and trespassed on their land. So you're not even really supposed to be behind, in the bar per se. There's very select times that you would even want to, but yeah. yeah, there's so many different terms, like, write off of debts is charging off, or essentially, writing them down, as uncollectible, and essentially just writing them off on the taxes. That's what a write off is. Entering into a contract, service a process. Service is process is service upon vessels, giving due notice to an opposing vessel or an enemy vessel. Like under the rules of engagement under NATO or the laws of war. That's kind of what that relates to. There are a number of things there that you got to be aware of. If you're unfamiliar, like the normal phraseology, you get some familiarity. Watching court cases will help you it'll help you familiarize yourself with the terms themselves. There are a lot of Latin phrases. Amicus curiae, friend of the court. When you hear an amicus brief, that's what that's referring to. A brief as a friend of the court. When you hear, let me see, res ipsa loquitur or something like that, it's like circumstantial evidence. If you hear like res ipsa duzi, that's like preponderance, like a heavy circumstantial evidence that can somewhat necessitate certain things. But there's a myriad of different, sui juris, of one's own right, propria persona, improper person. Compos mentis, of composed mind. Let me see what else. There's a few different ones. And one of the biggest things to realize is that, especially with these commercial entities, especially up under the 14th Amendment, they're setting up, commercial identities. They're using unlawful converting your name into an estate. So, that is one of the things there, to be aware of. So what do you do in that event? Like, how do you reclaim your identity? Well, for one, you check the state statutes. So this is just one example. This is an entire title, and it is under the Business and Commerce Code in Texas. So, but it says, but unauthorized use. Where's the application? Application. So it says right here, application for a court order to declare individual victim of identity theft. So they have state statutes there for this. You just have to realistically look at what it actually is, and because if someone else is taking your name and running up a whole bunch of debts in your name without your consent, I would look up the Title 15 and for the definitions and things like that for more information. But that's what identity theft is somebody's taking your name, racking up a whole lot of debts, and leaving you with the responsibility of it. That's identity theft, especially when you didn't authorize it. So it gives you those things there. And there's other things you'll want to add in there. This is where I say, like, I don't even know. Most of the time, I don't think there's just a generic form for this particular aspect. There might be, but even then, I would prefer a custom, petition or application in this aspect. So you see confidentiality order is confidential. These right there. So this is something that can be, you'll have to look into more on your own. ChatGPT, So what are the alternate methods of perfecting and enforcing security interests other than UCC financing statements fraudulently arising from identity theft? So there are alternate methods of perfecting and enforcing security interests depending on the type of collateral involved and the jurisdiction governing the interest. Below are some methods that do not involve UCC financing statements and are often more secure when seeking remedies outside potential fraudulent filings. Possession. For tangible collateral such as negotiable instruments, securities, or goods, perfection can occur through a physical possession by the secured party. This method eliminates disputes over filings. Examples: holding a stock certificate, maybe a bill of lading, or, a death certificate, or something along those lines, or a valuable piece of artist collateral. Control. Some types of collateral, like deposit accounts, electronic chattel paper, investment property, or letter of credit rights, are perfected by control. The secured party directly controls access or transfer rights. Example: a bank's control agreement for a deposit account, access to an electronic record in an authenticated system. Automatic perfection. Certain security interests are perfected automatically upon attachment and do not require further steps. Purchase money security interests in consumer goods. An assignment of accounts receivable that does not involve a significant portion of the assigner's accounts. So assignment. So deeds of trust or mortgages. Security interests in real property are typically perfected by recording a deed of trust or mortgage in the local land records office. Possessory liens. Created by law rather than agreement, these are perfected by retaining possession of the property, mechanics, artisans liens, things like that. Judicial lien. By obtaining a court order or judgment lien, a creditor may enforce their security interest. This involves recording the judgment with the appropriate authority, example given, a county clerk's office. Trust structures. An express trust can be used to secure an interest by holding property in trust for a beneficiary, with the trustee having enforceable obligations. A trust indenture and bond issuance. Assignment of rights. Assigning rights under a contract or agreement to the secured party can create an enforceable security interest. This is common with intellectual property or receivables. Accounts receivables are debts. Accounts payables are assets, generally speaking. Yep. Notice and acknowledgement. Directly notifying relevant parties of the security interest can perfect the interest in certain situations, particularly in equity jurisdictions. Letters of credit and guarantees. Collateralizing obligations using third-party guarantees or letters of credit provides enforceability without needing traditional UCC filings. Treaties and common law. Enforcing through specific common law or treaty-based rights, such as those established by the Treaty of Paris, 1783, or Geneva Convention principles for recovering property tied to identity theft. Private administrative processes. Notice how it says private administrative processes, meaning it has to stay private. It doesn't go out in the public. Those are trade secrets. If arising from identity theft, corrective actions may involve private administrative remedies, including notice of claim to administrative agencies, affidavits of truth, and notices of fraudulent filing sent to the Secretary of State. Equitable enforcement. Equity courts provide remedies for enforcement when fraud or identity theft is alleged. This might include injunctions, constructive trusts, or reformation of documents. Considerations. Evidence of fraud. Establish a clear record of identity theft or fraudulent origination to dispute UCC filings or assert claims for wrongful conduct. Use equitable powers of the court to demand removal or cancellation of fraudulent filings. And confidentiality. Exercise discretion by filing sensitive documents under seal if necessary to protect privacy and prevent misuse of information. If pursuing a remedy, careful documentation and an understanding of the collateral's nature and jurisdictional laws are critical. So how might an assignment be done to properly and effectively enforce those said security interests to automate perfection? To properly and effectively enforce security interests through assignment and automate perfection, you need to structure the assignment process with precision, ensuring it meets legal requirements and eliminates the need for additional filings. Here's how. Identify the collateral clearly. Define the assets being assigned as collateral in detail. Example given: accounts receivable, intellectual property rights, financial instruments, or tangible goods. Ensure the description is specific enough to avoid ambiguity, but broad enough to cover future interests if applicable. Draft an assignment agreement. Parties, consideration, collateral, automated perfection clause, possession, control, third-party notification, notify parties, control agreements, ensure compliance. It's your duty to enforce that and notify them of breach. They're your trade secrets and the court is trying to breach them, so you have the duty to prevent the breach and remind them of such breach. That, you know, the nature of the information or the trade secrets. Create an assignment chain, securitization, file for record, invoke equitable powers or trust mechanisms. So it gives you a structure here. Assignor executes an assignment agreement transferring all rights to future receivables to the assignee. The agreement includes an automatic notification clause requiring all payors to remit payments directly to the assignee. The control system monitors receivables, ensuring compliance without additional filings. And for the assignee, notifies relevant third parties and secures payments without the need for further perfection actions. And then it gives you an example. We have that here. So it gives you that. So UCC financing statements are not the only way to perfect an interest in tangible, intangible, or real property. Most people flock to the UCC financing statement and they just automatically assume that's the only way it can be done. A security interest. So, you know, that is something that you can do. So that is something there. Now let me find out what is. You know, what you might ask is, you know, well, what is an assignment? Well, UCC. So, delegation of performance. So it says here, I don't know. UCC 2-210, and it's very, very important to note that when you're quoting anything in any particular Uniform Commercial Code, a subsection, or anything, you're not quoting the UCC unless there's a specific provision in the state statutes where they've codified it and adopted it for the state, that it says this title may be, referenced as or is referred to as UCC section such and such. Other than that, you call it exactly how it's codified in the state. Whatever state you're dealing with, wherever the property is, or wherever whatever place of jurisdiction under that, particular adoption of the UCC, you use that state statutes and codification of the UCC. You don't use UCC. UCC is the original proposed amendment that all these states enacted and changed the name and codified in their own, titles. So what it says here, party may perform his duty through a delegate unless otherwise agreed, or unless the other party has a substantial interest in having this original promisor perform or control the acts required by the contract. No delegation of performance relieves the party delegating of any duty to perform or any liability for breach. So an assignment is essentially like an equitable lien, allowing the right, which is also the trust, the right, because a trust is a specific type of right against the trustee. So that assignment of right then comes with the duty of performance as well, the rights of ownership, the duties to perform, and that's what's happening. Unless otherwise agreed, all rights of either seller or buyer can be assigned, except where the assignment would materially change the duty of the other party or increase materially the burden or risk imposed on him by his contract, or impair materially his chance of obtaining future return performance. A right to damages for breach of the whole contract, or a right arising out of the assigner's due performance of his entire obligation, can be assigned despite agreement otherwise, unless the circumstances indicate the contrary. A prohibition of assignment of the contract is to be construed as barring only the delegation to the assignee of the assigner's performance. An assignment of the contract, or of all my rights under the contract, or an assignment in similar general terms, is an assignment of rights unless the language or the circumstances, as in the assignment for security, indicate the contrary. It is a delegation of performance of the duties of the assignor, and its acceptance by the assignee constitutes a promise by him to perform those duties. This promise is enforceable by either the assignor or the other party to the original contract. The other party may treat an assignment which delegates performance as creating reasonable grounds for insecurity, and may, without prejudice to his rights against the assignor, demand assurances from the assignee. Section 2-609. So it said there, most of the time it is a delegation of performance, but it made one small exception. Let me see where it was. It was dealing with security. General terms is an assignment of rights, and unless the language or the circumstances, as in an assignment for security, indicate the contrary. So you see what the broad and general definition is, and then it changes for a security interest. So, but that's that's something. Trust directive or something like that. Non-precatory language. That would be something that you could use in that event. That non-precatory language is, avoiding words like I hope or I wish or, I desire. Those used to create trusts, but they don't anymore. Not since there was case precedent against that. So now you have to be very clear. I direct, I order, I command. This property is to be done XYZ with this. Very clear communications. So those are definitely some things that should be taken into consideration when dealing with perfections of security interests and other things like that. So that is something there. Any questions on that? No, that's precatory. I pray is not strong enough. Non-precatory language is also something it talks about in Gilbert's law summaries on the law of trusts. So, I would refer to that. It's not, like I said, I direct, I command, I order, or even I hereby convey, or I hereby transfer, or I hereby, assign such, something in some strong language to actually affect a clear indication and the clear intent and purpose to create a transfer or something along those lines. So, especially when dealing with trusts, you have to use non-precatory language. So, but that is something there that should be taken into consideration. Everybody flocks to the UCC financing statement, and there's a lot of people that aren't able to do it like that anymore since it's been used and abused. So there are other methods of getting the same thing done. So I think they are, but that specific, I'd have to look more into it. I know that they're doing certain things. Well, are you talking about the HJR 192? Yeah, absolutely. That's still in effect. Proclamation 2039 and Proclamation 2040, the State of Emergency and the Emergency Banking Act. Yeah, they're still doing that. They really are. Yeah, they're doing a lot of things, honestly. And they still do to this day. But that's something there, especially if you're appointing someone a fiduciary or something else like that, orally and for the record or something like that, especially in a setting like a court, you have to say on and for the record, I hereby appoint, so-and-so as fiduciary, whoever it is, court, judge, I wouldn't say judge, but the court, the treasury, the other party, I hereby appoint them fiduciary, under the Powers of Appointment Act of 1951 to settle, close, and terminate this matter. Things like that. 14th Amendment is just a corporation. So, but that's what you're dealing with there. So, but any other questions? Any questions on that? I know that there's a lot of language that there's very key differences in language as far as how they interact, especially in court settings. There's certain key things, realistically, if you understand taxation and you understand, the wording with taxation, assignment of rights and appointments, fiduciary powers, how fiduciary powers are taxable under that same act I mentioned, because the fiduciary or the trustee always pays the taxes owed, things like that. So, there's things to be aware of. And, everybody's looking for an Article 3 court. If, let's say, for example, the United States is a federal corporation, done under by an act of Congress, then wouldn't that make everything done under a legislative power? There would technically be no Article 3 courts. Is that why we're in the position we are today? It just makes you wonder. Well, it indicates a contract with the state, with vital statistics, your mother and you. So, there's certain court cases that talk about that. Northern Pipeline versus Marathon Pipeline, Stern versus Marshall. But yeah. So, and that's something, like the birth certificate is, like I said, it's an unconscionable contract, because if you knew better, you would do better. And yeah, and that's something that I really like to pay attention to is maxims in case law. Case law shows what's applicable, maxims show what's universally true. So those two combine together and form a very strong, when done with reason and proper application, it provides a very compelling argument. So no, well, there's an argument against the contrary, but they say publicly no. So, but I suggest everybody look up those particular cases. Those particular cases are very strong. Holmberg versus Holmberg, Northern Pipeline versus Marathon Pipeline, Stern versus Marshall, etc. Those are ones to take note of. So one of the biggest things is understanding UCC 1-308. Everybody quotes it. Most people aren't aware of it. So, it says a party that with explicit reservation of rights performs or promises performance, an obligation, a debt, or assents to performance in a manner demanded or offered by the other party, does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, or the like are sufficient. It says it does not apply to accord and satisfaction. So, let's see. So yeah, let's look at what you were talking about. 3-402. So that's prejudicial actions with 1-308. That means they're taking a prejudice against you and they're acting on presumption of law. So let's take a look. You said 3-402. Let's take. Oh, authorized representative. Yeah. So 3-402 governs authorized representatives. This is an endorsement. However, there's still times when you want to sign by both, without prejudice by authorized representative, and you don't incur liability for acting on behalf of the principal debtor, as long as it's done in good faith and you're not being negligent. That's something there. So but let me see, what else can be done. There's a number of things that can be done, actually. So, but like I said, everyone has like one mode or one thought process on a lot of these, governing perfection of security interests, and generally, even on identity theft, you do need to rebut the fraudulent liens and, secure certain rights via several different methods. I mean, generally, I would do at least 2 to 3 to 4 different things. Realistically, you want to do everything, but you want to have a substantial case to actually bring into court. So that's one of those things. An agreement, control agreement, assignment agreement, deed of trust, or a mortgage on the property, etc. So certain types of liens, certain types of other things, you'll want to realistically, you'll want to perfect it via a multitude of methods and take care of certain things. So that is something there that you'll want to, like I said, you don't want to just have all your eggs in one basket in that sense, because they look to poke holes in a lot of arguments, and that's why a lot of attorneys use multiple points of law, multiple points. They're arguing technicality, but you're arguing substance. Not arguing substance, presenting the substance of the matter in a particular light, not causing a controversy, but settling the matter. And there's a very big difference. So when you handle that accordingly, you don't have to worry about, being the cause of or being labeled belligerent, because when you bring it in the right way, they recognize that you're handling the matter prudently. With the duty of care and confidentiality, because they do hold you to a business standard regardless of whether you know or not. And that's why people a lot of times have issues with this, because most people don't know how to conduct business. Generally you don't go around telling people your business. It's one thing if you're advertising, but even then you have to take certain precautions and disclaimers and preventions of certain things. But even then, you want to make sure you go about court the right manner. Another thing is, if you're dealing with court, you really want to be going in there, with all of your ducks in a row. You don't want to go over there with all your different remedies and all that, and half cocked and not really ready to show of hands, like at the poker table. When the pot gets distributed, you really want to have everything lined up. And realistically, like when you're presenting specific circumstances and facts of the matter, especially when you're looking to compel a judge or a judicial officer to actually grant performance by the court, or grant some injunctive relief or restraining order, or some other type of equitable relief, or any outlaw remedy, you really do want to make sure that it is compelling. And I understand there are some circumstances where you can only do your best, and all the things you might be under duress, you might be under emotional distress, it might have literally the whole world against you sometimes. And there's just sometimes when you just can't. All you can do is the best that you can. I mean, your best is the best at that moment. Like, I've had my days when I've had My best for this day might not have been nearly as good as my best other days, but all you can do is the best you can for the temporary moment and at that moment. So basically, you should already have the entire case and the matter there. Realistically, they're there just for verification of information and other things, which is why you can go ahead and getting rid of the hearsay rules and making sure that things aren't considered hearsay is one of those biggest things. Look up the rules of evidence, look up how cases are actually handled, the rules of procedure, etc. So be aware of things like that. So UCC I don't really use that much. I do use authorized representative in when I'm in the public. Generally, yeah. If you go into courts, it's presumed that it's a private matter until you bring in public notice. Public notice is things on the public record. So, there's several different methods to get things on the public record. But bringing in evidence on the public record and then having certain things attested by an officer of the court, notary public, other things like that, you do need to make sure that you have proper disclaimers so that you're not entering into a foreign jurisdiction via adhesion contracts. But you do want to make sure that everything is in a row, and you have your presentment, your brief or your petition or your complaint or whatever it is, however it is you're presenting the information to the court. You're presenting your side of the story in a manner that conveys the emotion, conveys the urgency, and is in a concise and format that flows in a essentially like a melody. Like the reason why good songs go so far is because they carry the emotions throughout the song. They have highs, they have lows, but they are reminiscent of times and places in life that people can easily relate to. So in that same essence, writing your documents, you're the composer beforehand. You have to draw up the notes and the melodies, and it takes quite a bit of more information and understanding to do that ahead of time, to be honest, which is why it takes, especially when you're not used to it, it takes a good bit longer sometimes. But that is something that you have to be aware of and account for accordingly. But drafting it up and doing certain things helps you to understand and be able to actually present your brief, or how's it going, and take care of you take care of your business, handle your matter effectively. And that's, like I said, I've been drafting up documents for like 5 years. I've been drafting up English papers for longer than that. I had pretty tough level of grammar and English classes in high school, and presenting research papers and other things like that, in business proposals and other things. So I've had a few years of experience. But even then, even if you're just starting with this, understand how if you don't know anything, just present it in a research paper format and then tailor it to the court. Multiple, and it is, but it is, you have to understand that if you go in representing yourself, or you can't represent yourself. You can't pretend to be the person. You have to be the authorized representative on behalf of the person. So there's very key things you have to be aware of. And, the courts are not lenient at all to pro se filers, because they, pro se filers are essentially a chink in the system, like a chink in armor of the entire system, because if you, interrupt their monopoly of attorneys, then they view that as a threat. Why? I'll leave you to guess on that. But they demand a lawyer for everyone and everything for a reason. So, an attorney can only represent wards of the court. any clients of attorneys are considered wards and insane persons. So you have to understand that if you're going in representing, on your own behalf, or you're on behalf of your person or fictional person, the courts are already set a salute against you. So don't let it stop you. Your circumstances are your circumstances, but bear that in mind. Don't let it, don't worry about it per se, but you have to be cognizant of certain things and take those things into account. So, they're not there to help you. The courts really aren't. You have to go in, and stand on what you know. You have to present, a clear and concise, nature of the facts, the cause of action. The mode of action has to be correct. You have to double check with these things. Cross-referencing with ChatGPT is good. Make sure you have a baseline understanding of what it is you're looking for before you go and ask ChatGPT. Otherwise, you'll go off the rails. But you do have to. You have to prepare ahead of time. And when you present something in court, generally you want to practice. It's like a speech. It's like giving a presentation or a performance in music. They are helpful. They are helpful. Sometimes I'll give you the I can't give legal advice, blah blah blah, but it's, you press hard enough for certain things and you show that you do due diligence and search XYZ and all this stuff. A lot of times if you just need to be pointed in the right direction, a lot of times they'll do that. So it just depends. But just telling you how to do everything, generally they won't do that. But it just like a performance or something, presentation of music or business plan, anything in those manners, they have to be rehearsed. This is why you have music rehearsals. So if you got to sit there in front of a wall on the phone with somebody and trust, if you got to be talking to outside, just to the trees in the air and everything, and just do what you got to do. Understanding what they might say, and other things like that is a good thing. They're looking to trip you up in any form of technicality in law. So generally there are certain remedies that help. Without certain remedies, a lot of times you'll just be kind of hanging in the water. But so you have your role in composing it beforehand. And so you have to compose the bars of the music in a way that they convey the emotion, they convey the substance and facts, and they present it in a light that's favorable to you, shows their unclean hands without just simply slandering or libeling them, and it shows that you've done your best to maintain clean hands in the matter. I'd be aware, matters not what a judge knows if it is not known to him judicially. So mandatory judicial notice of just about everything and anything in the court is something I would probably take note of, just because of that maxim by its, in and of itself. So you do want to make sure that you prepare certain things. If for some reason you have to use emotion in a specific light, read the entire statute regarding that motion and the rules of procedure. So a lot of times certain states have certain codified procedures, like you might have to give a notice of certain motions. You might have to give XYZ, for certain things. It just depends on what it is. If you're going to file something under seal, some places require a notice of that motion to give due notice to the other parties. It just depends on what you're dealing with. So you're going to want to make sure to handle that in the proper way. But yeah, so after you've rehearsed it, you've thought about the counter arguments, you've got answers to the counter arguments, and you keep everything in a particular manner. Preparing for the day of, the best you can do is the best you can do. If generally speaking, you want to be able to make sure that you're at least, mentally and well enough equipped to where you're not just you're not just so tired that you can't even function. If you have to get some rest, you get some rest. But generally speaking, you want to be reviewing your notes and looking over different things. Like I said, there's a much heavier burden upon pro se filers than there are with attorneys or any other people in the law profession. It is very unfair. Quite simply, it is very unfair. The only thing that can be done is to change the amount of litigation that you actually do after correcting this, not needless and in wanton manner going and suing for everything, and still claiming your minor accounts and other things to prove you're above the age of majority. But in that aspect, you really do have to get to the point, because there's a lot of judges that are quite clearly, very, very clearly against pro se filers because of disdain and other things and other movements that have been done in the past. That may be all that a judge knows. Like I said, you might find it, but don't look for leniency in that aspect. Show up ready to essentially. You're not really there to do battle, but you have to be ready to counter the presumptions of law. And a lot of times they come at you with them, and it's a war of perception. So you're not looking to be a hostile or a belligerent, because then they'll put all kinds of labels on you. But there's no such thing as a license to practice law. There's no such thing. The bar license is not a license to practice law. So, yeah. That's one thing that people aren't aware of, But yeah, don't add fluff. I get it if you have to obtain more time or certain other things, but generally you want to have substance behind your reasoning and other things. You don't just want to waste the court's time and other things like that, So generally you just want to settle and close and terminate the matter in its entirety. So that way you can handle it honorably. And but yeah, like I said, that is something you do need to be aware of when you're going in and dealing with anything in litigation. So and there are opportunities, like I said, you bring certain things about in trade secrets. You handle it accordingly, depending on how you handle it, what court you're in, whether you have to put a motion to file under seal, protective order, etc. Just depends on what it is. But generally, you gotta tailor it to the specific matter. It's usually not a one-size-fits-all. So that's why there's so much due diligence required. And this is why they have lawyers specifically for certain types of law, specifically for this, specifically for that. A lot of lawyers don't ever leave their original jurisdiction where they practice. They just do one mode of things and all this, and for their entire lives. This is why the burden of proof is so heavy upon pro se filers, because they only have to study one aspect or one area of procedure or law or what statute and code, whereas pro se filers have to understand so much more than that. There's a very, very heavy duty upon. So like I said, you got to go in, prepare your affairs, and you have to be as prepared as you would to do battle, but you have to realize you're there only for basically the purposes of business. So it's strenuous like war, but it's got to be peaceful like business. So yeah, attorneys, most of them aren't really that well versed in other areas of law than the ones they specialize in. So that's why you have specific types of attorneys and specific types of lawyers. But yeah, like I said, pro se, you have to understand where the lines are, where they're at, and how to go about things, because those attorneys, most of them don't know. Most of them don't know where the lines are drawn, and a lot of judges have to be reminded a lot of times. But you have to really know. You have to do your due diligence, 2 to 3 witnesses on any given fact, have those witnesses there for the court to see. Records, not just actual witnesses, but records or proofs as witnesses to back up what you say. Whether it's an entity, whether it's a type of document, certified document, recording, filing, financing statement, etc., agreement, treaty. It doesn't matter what it is. You got to make sure that you have all your stuff together and ready to present. Because like I said, this is business. They do business in the courts. So, especially if you're looking to prove that you're above the age of majority, you've got to be organized, have all your stuff in a row, and be prepared. Like I said, I know it's not fair a lot of times. A lot of these times there are corrupt officials, and they bring actions thinking that they can just do whatever to their so-called wards. But, you have to challenge the presumptions in a peaceful manner. So, like I said, you don't want to be called a hostile or a belligerent, but there's a way and a method to do things in a precise manner to change the perception in your favor. It has to be done the correct way. So, but yeah, those are some of the things to look out for, especially when you're dealing with that. So, if you're looking, at whatever it is, So, presumption in law is a legal assumption that a court makes based on certain facts or circumstances. Presumptions are important in both civil or criminal law because they can shift the burden of proof and streamline legal proceedings. So, this is why the burden of proof is so heavy, because there are so many presumptions nowadays because of past case precedent, Supreme Court and otherwise. So what are some types of presumptions? Rebuttable presumption. Presumption that can be disproved by evidence. For example, a child born to a married couple is presumed to be the husband's child, but if this presumption can be rebutted with evidence to the contrary. Conclusive presumption. Presumption that cannot be disproved and must be accepted as true. The United States Supreme Court has described a conclusive presumption as an irrebuttable direction. Inconsistent presumptions. If there are multiple presumptions that conflict with each other, the court will apply the presumption that is based on the most important public policy considerations. So they construe it in favor of the courts. So it's also a presumption of law has been defined as a deduction which the law expressly directs to be made from particular facts. In actuality, it is a rule of law which declares that one fact is presumed to exist if another fact or set of facts is proved. So, another word for this might be inference. What are they inferring from the circumstances? That creates this presumption of law and this assumption of certain facts. So, it's not real law because it's not based on certain, hard facts, but it's based on certain circumstantial evidence. Case outcomes affect everything. Proper cases, capital cases, criminal cases, civil cases, equitable cases, all of them. They all affect, all cases are trusts. All accounts are cases. So you have to be, aware of these things. These are all different things you need to be looking towards. So How do you rebut a presumption of law? You must present sufficient evidence. That means you have to meet or exceed the burden of proof. And you must present sufficient evidence that contradicts the presumed fact. Effectively proving the opposite conclusion is more likely true based on the legal standard required for the specific case, which is usually, quote, a preponderance of evidence. This is one of the levels of evidence to be aware of. In civil cases and beyond a reasonable doubt, in criminal cases, this means you need to provide clear and convincing evidence that outweighs the initial presumption established by law. Understand the presumption. First, clearly identify the specific legal presumption that applies to your case and what facts trigger it. Gather relevant evidence. Collect evidence that directly contradicts the presumed fact, including witness testimony, documents, expert opinions, or physical evidence that supports your counter-argument. Present your evidence persuasively. Clearly articulate how your evidence undermines the presumption and demonstrates the alternative conclusion is more likely true. Meet the burden of proof. Depending on the jurisdiction and the legal issue, you may need to meet a higher standard of proof to successfully rebut a presumption, like clear and convincing evidence. Example, a presumption. In a child custody case, there might be a presumption that joint custody is the child's best interest if the parents are able to cooperate. Rebuttal. If one parent presents evidence of a significant domestic violence or a history of one parent being unable to consistently provide for the child's needs, they could potentially rebut the presumption and argue for sole custody. So, this is something to be, taken into account. So you'll realistically, you'll want to, summons is a writ. A writ are ancient types of writings that are considered circular in nature. They have to be performed. They compel the officers of the court to perform the specific duty. But they're much more powerful than, generally speaking, orders per se. There's certain ones: writ of summons, writ of praecape, writ of certiorari, writ of mandamus, writ of execution. Fieri facias is one of those. Writ of garnishment is a writ. Writ of attachment. There's plenty of writs. There's multiple types of writs. So generally it does test your skills, but it's not. It's there essentially commanding you. They have that power over you in that essence, but they're commanding you to be appeared before the court. That's what they're demanding from you. So you'll want to really look over certain things. So this is Federal Rules of Evidence. So it says presumptions in civil cases. Generally, in a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. But this rule does not shift the burden of persuasion, which remains only on the party who had it originally. So you notice that, when it talks about in Scripture the eloquent tongue, that's what it's talking about. So yeah, the original party creating the presumption still has the burden of persuasion. This is why these people like to lie and do certain things to create horribly heavy presumptions. But you have to handle the presumption itself. You have to meet or exceed the burden of proof required to shift and put the ball in their court. And put that hot potato back in their hands. So that's how you have to, do that. Like I said, I would look at the rules of evidence. There's, preponderance of evidence, clear and convincing evidence, and then beyond a reasonable doubt, there's certain levels to, evidence and levels of that you have to meet or exceed. So, and basically they're generally looked at as, based on the circumstances. So you have to look at case precedent, you have to understand what has already been decided, and you have to, take into account those things. Judges like to adhere to past precedent. So if you have something that requires a change or requires something that's much, far, how do you say that? If you have a case that's not necessarily a common case, or you're looking to prove something that's outside the common realm or common presumptions of, normal circumstances for everyday life, the burden of proof will generally be higher. But it's still your duty and still your burden until you meet or exceed that. And then once that's done, then it's changed. So, you're gonna have to be aware of these different things. So really do your due diligence. If you have a court matter and you're not familiar with court proceedings, I would be researching and reading the rules of evidence, reading the rules of civil procedure, understanding the maxims, understanding case law, understanding what cases apply to your case, So, let's see, they have plenty of law reviews on multiple areas of law. So, they do teach you specific things in law school, but there are things you can study on your own. So, you'd be surprised how many things are available to the public, which is why they say, oh, it's public record. So, but you have the duty of due diligence. So, it's a lot of duties and burdens, but that's why you have to perform. Starting somewhere is, better than just leaving it to oblivion. So, a waste of time to devote even a few pages to the subject and students makes the whole matter a very simple one. The term burden of proof is used in a primary sense. The burden of overcoming the inertia of the court, which is fixed by pleadings and never changes. And in a secondary sense, the burden of producing evidence, which may shift as the weight of the evidence on the one side or the other so far preponderates as, if no further evidence were given, to require a ruling by the court, which would in effect take the matter from the jury, or it may shift as some presumption operates to give to the evidence of the effect of prima facie proof. Prima facie means at first glance or at first face. It means that your evidence has to be, on its face, directly rebutting whatever presumption of law. The term presumption is used in a variety of senses, but the only one form of presumption, quote, the rebuttable presumption of law, is a true rule of evidence, and its only effect is to shift the burden of producing evidence. Nothing could be simpler, more easily administered, more effective to prevent confusion and conflict. Yet there is no class of case more confused or confusing, more difficult to analyze and rationalize than those which deal with the effect of presumptions on the burden of proof. Absolutely. The settled practice in at least one important jurisdiction denies the theory in toto. In toto just means in total. Toto in Latin means the entirety. And in every jurisdiction there are certain presumptions, not mere presumptions of fact, mere expressions of judicial experience as to the probative value of certain data. Not, on the other hand, conclusive presumptions of law, judicial legislative, masquerading as an exercise of the court's admitted supervisory power in matter of evidence, meaning legislating from the bench, creating presumptions from doing so, but true rebuttable presumptions of law to which the converse of the theory is applied. Professor James Bradley Thayer regards them as being rather part of those portions of the substantive law to which they severally relate than as part of the law of evidence. Many of these do operate in rather restricted fields, and to that extent may appear part of the substantive law to which they apply, but so do many of those presumptions which only shift the burden of producing evidence. In fact, there is no presumption universal to the whole field of proof. The greatest living authority on the subject of evidence says, quote, "Sometimes the ruling involves the first, quote, burden of proof, i.e. the risk of non-persuasion of the jury. That is in strictness and usually a question of pleading rather than of evidence," end quote. Yet his own book, as well as the other texts and case books on the subject of evidence, give instances of such rulings under the title presumptions. And courts rarely, if ever, treat such rulings as laying down principles of pleading. While it is doubtful whether such presumptions are more limited in operation than presumptions which merely change the burden of producing evidence, and while to regard them as, quote, in strictness dealing with questions of pleading may require a complete revision of the normal and usual concept of pleading. The important thing is to recognize that such presumptions do exist, and to discover the reasons for their existence and effect, instead of dismissing them as mere alien interlopers into the law of evidence, and as such unworthy of serious consideration. So, the term presumption is used by both text writers and judges in a variety of senses, among others the following, as a synonym for inference. So a presumption is an inference of certain circumstances and facts that they have deduced, like this says here, to create the most plausible situation that could have occurred. And this is what they presume happened. That's why it's called a presumption. There's a certain level of assumption that goes into this. So, bear that in mind. As laying down a rule for requiring the assumption, the taking for granted of certain facts upon data whose probative force falls short of that strength usually required to justify or require such fact to be inferred. As stating a change in the substantive law, while apparently exercising the court's long admitted power to supervise the jury's exercise of its function of judging the effect of evidence produced before it. So long as an individual judge is stating in terms of a so-called presumption his own opinion as to the inferences that may, should, or must be drawn from the data before him and the jury, he is laying down no rule of law. But when a court, considered as perpetual, though its membership changes, in the exercise of its judicial functions, acquire experience in the valuation of the probative force of constantly recurring data, binding traditions arise as to the inferences which may, should, or must be drawn from certain data. Such traditions, like rules of construction, have the force of law, constructive trust. But though of great practical importance, they are so numerous and vary so greatly in different jurisdictions that an attempt to enumerate and there's no way to do it for every circumstance. Therefore, to reduce the law of evidence to a manageable size, they are ignored, except where there is a unanimity of judicial opinion as to the effect of data which frequently come before substantially all courts. The so-called presumptions by which the court gives to the temporary and transient jury the aid of its experience, accumulated during years and even centuries of dealings with similar data, by advising and admonishing them to give effect to their own opinion as to the probative value of the data submitted to them, if a part of the law of evidence at all, are part of that portion of it which deals with the relevancy or weight of evidence. Yeah. Do I have a definition of sovereign? Not offhand. I can look it up in a minute if you have it. On the other hand, the theoretical concept that the function of the courts is to apply without change the traditions and precedents of the past has laid a taboo upon judicial legislation. In theory, only the legislature can change the law. The court's duty is to administer it. To overcome this taboo, to make the law livable under changed conditions, to make it tolerable to a changed public opinion, while appearing to preserve a reverent adherence to tradition, courts have, in addition to resorting to directly stated legal fictions, used their admitted power of supervising and directing the jury in the exercise of its functions of judging the effect of data produced before it, to make such changes, often very radical, as seem to them necessary. Rebuttable presumptions of law. What page is this? 311. University of Pennsylvania Law Review and American Law Register, 1852, or June 1920, volume 68. The effect of rebuttable presumptions of law upon the burden of proof. They have created many presumptions, commonly called conclusive presumptions of law, which require the jury to find some legally important fact from data, which does not necessarily imply its existence, and forbidding the production of even the most direct and convincing proof of its non-existence. Such presumptions have obviously no place in the law of evidence. The very fact that no evidence can be given to prove the invalidity of such presumption shows plainly that the fact has ceased to be of exclusive legal importance. Such a presumption concerns the law of proof to exactly the same extent as other changes in the substantive law. It affects the object and not the means of proof. The quote may now either prove it or the data on which the presumption rests. He has an additional target at which to aim. There are now two sets of facts, the proof of either one of which is as great a legal effect as the proof of the single one previously was. But between the so-called presumption, which only expressed the court's opinion of the probative value of data before it and the jury, and the conclusive presumption of law, which is judicial legislation, there are a large mass of presumptions permitting or requiring the jury to presume or take for granted a fact upon data, normally insufficient to justify or require a finding that it exists, but, however, permitting the presumption to be rebutted or overthrown. They permit or require the jury to take for granted the existence of the fact presumed upon data, which lacks that probative value usually required to justify or require such a finding. It is this additional force given to the data by the presumption which is its legal effect. Since the presumption only operates till nullified or overthrown by the production of evidence rendering doubtful or proving the non-existence of the facts presumed by it, it does not change the substantive law. The fact presumed has not ceased to be of exclusive legal importance. Such a presumption is a rule of law, and since, until rebutted, it is so far established as a fact as to require the adjudication of the rights of litigants on the basis of its existence, it is a rule of the law of evidence, and it is not a rule of that part of the law of evidence which deals with relevancy, since it attaches to the data on which it rests a value as proof which its probative force would not, but for the presumption, warrant. Basically, these which have to be acted upon to continue the operation of the courts. There's something in scripture that talks about the wise having no regard for persons in judgment. There's a very clear reason why. Because without it, too many things are presumed and assumed, and as a result, lives and livelihoods are damaged and injured to a great extent. the necessity of relaxing the stringent of proof in theory required to justify or require an inference or finding of certain facts. And 2, the desire to determine, if possible, certain rights and duties as though certain facts existed. And it is submitted that the force of each presumption and its effect as shifting the burden of overcoming the inertia of the court, or of only shifting the burden of producing evidence, depends upon the nature of the need or purpose which has led to the recognition of that presumption. The requirement of proof to that degree of certainty which the common law in theory demands, if strictly insisted upon in certain constantly recurring situations, would result in waste of time or in a denial of justice to those whose rights depend upon facts which in their nature are usually incapable of strict proof. The need of relaxing the stringency of proof in theory required by the common law has led courts to create certain presumptions. These presumptions arise in 3 situations. 1, where the fact assumed so usually exists that to require the production of evidence to establish its existence would cause unnecessary waste of time, money, and effort of both courts and litigants. 2, where the rights of litigants depend upon facts which, from their nature, are usually incapable of proof to the certainty, or by that sort of evidence which theoretically is alone regarded as legally probative. And 3, when the power to produce evidence of the fact on which the litigant's rights depend is exclusively in the power of the opponent of him, who, having the risk of persuasion, should in theory also bear the burden of producing evidence sufficient to persuade. In all of these, the need is satisfied when evidence is produced. Having accomplished their purpose, they have, of course, no further effect. Like, oh wow, I can't pronounce that. Like so-and-so's male B, having functioned, they disappear. If evidence is given sufficient to cast a doubt upon the existence of a fact so usual that its existence may, in absence of evidence, usually be safely assumed, the presumption based on the desire to save unnecessary waste of time and effort disappears, since the time and effort is now seen to be no longer mere waste, but a necessary expenditure to clear up a real doubt. Outliers, dealing with the bell curve, glitches, glitches in the matrix, etc., anomalies in data. At all events, when evidence on both sides is produced, the time and effort have been expended. The purpose of the presumption has failed, and it ceases to exist. So in those few presumptions, which are based on the usual impossibility of proving certain legal important facts, is if there is evidence, whether direct or circumstantial, amounting to legal proof of such facts, the very basis of the presumption. The assumed impossibility of strict proof fails, carrying with it the presumption based upon it. Where a presumption is recognized because the power of producing evidence is exclusively in the opponent of him who has the burden of persuasion, insofar as it is recognized for the purpose of relieving him of the burden which is impossible for him to successfully bear, that purpose is satisfied when his opponent produces evidence of what actually took place. What is that? Sounds like Freedom of Information Act and Privacy Act, maybe? There is no reason why the risk of persuasion should be shifted that the defendant, let us say, since such presumptions usually arise in aid of a plaintiff in an action, on the case for negligence, should be forced to convince the jury that the facts, as proved, establish a preponderance of probability in favor of his innocence. If the defendant's witnesses are believed to have told the whole truth, and his records are accepted as full and accurate, the facts are known, and the plaintiff is in no worse position than if such facts had been proved by his own witnesses or books. No worries, Roots. I went over a couple things. I'll do my best, but yet many, what disadvantage he originally labored under has disappeared, and the presumption based on the desire to remove the disadvantage is satisfied. Yet many courts do hold, where the so-called doctrine of res ipsa loquitur applies, that not only the burden of producing evidence showing to the satisfaction of the jury what actually took place, but of convincing the jury that his conduct is not negligent, is shifted to the defendant. This is in part due to the failure to discriminate between proof by satisfactory evidence of the facts and persuasion as to whether those facts show conduct conforming to or falling short of that of a reasonable man under like circumstances. In part is due to a growing tendency to a compromise between the modern theory of tort liability as based exclusively on fault and the more modern renaissance of the ancient concept that everyone must answer for the harm done even by his most innocent acts, but not only raising the presumption of negligence upon the mere fact of the harm done, but by holding that such presumption requires the defendant to rebut it by proving that he has done all that is possible to prevent the harm that his activities has caused. This tendency chiefly appears in cases which the harm is done by what is called ultra-hazardous operations or businesses. The additional weight is given the presumption because the court desires to hold these engaged in such work to a strict accountability, without definitely breaking with the traditional concept of that there can be no liability without fault. And to this extent, the presumption becomes akin to those of the second class. So that's something there. But hopefully from that you'll be able to see presumptions of law are very damaging. And especially when you're dealing with, especially due to public ignorance or other things like that, or lack of knowledge on a wider scale, presumptions become much, much heavier when the public's knowledge derivates from the truth. So this is why the burden of proof is so heavy upon pro se filers, because there are very, very heavy presumptions, and frankly speaking, the masses are quite ignorant and decidedly, and by their own choices, very decidedly so, against seeking the truth. So, like I said, this is why, there's such a heavy presumption. But earlier, what I was going over, in case anyone missed it, was perfection of security interests. UCC financing statements are not the only means of perfection. There are other methods of perfecting interests in tangibles, intangibles, and real property. For real property, deeds of trusts or mortgages will suffice. For accounts receivables, particular ones, certain types of account numbers, things like that. Assignment agreements between assignor and assignee can automate perfection of the interest. And that's something ChatGPT did acknowledge. And as far as, control, certain accounts dealing with chattel paper and other things like that require control. So having the authenticated record or of some manner, or of the interest itself can automate perfection as well. So it just depends on, what's going on with that. But, there are, control and assignment agreements that perfect, an interest in property, other than just your standard financing statement under Article 9. Or another article for obtaining perfection via notice of claim of lien. So, I know today was pretty heavy. But, realistically, there's just giving different options. There's plenty there. Identity theft, there's specific statutory remedies for identity theft, and the necessity of essentially perfecting certain security interests to maintain and rebut certain presumptions of law arising out of identity theft are key and necessary when you're bringing certain types of suits. So that is something to be aware of. But it's there's a few different things that are going on with that. But like I said, any questions? I know I've covered quite a bit. Any questions at all? Like I said, put them in the chat. Because I know that, I've done a myriad of different UCC filings, and there's certain ones that you can put, but generally, lending more to identity theft and other things like that, while still giving notice to the public, there's several things that can be done. But it's not the only method of perfection. For example, if things aren't only that's good that sounds good, Carissa. Like I said, a motion to file under seal, so the state rules of civil procedure. Tomorrow I'll be going over quite a bit more as far as courts of original jurisdiction, case precedent, Supreme Court, Minnesota Supreme Court, applicability of certain cases, what that implies, inferences. But for now, I'm just going over some public side stuff. So, but that's, there's more options than people think. Everybody's only used to one method. There's plenty of other methods of perfection of interests and perfection of control. There's sometimes when certain types of decrees or orders are changed, even no, Supreme Court does no, they're a court of appellate jurisdiction, and they don't have original trial jurisdiction. They're only an appellate court. Yeah, ChatGPT does help. Although, I will sovereign ruler monarch. Oh, that's what you're talking about. Yeah, a monarch is a corporation sole. Corporation sole is under British law. You have several, at least from my knowledge, there's a couple types of corporations. One of them is a corporation aggregate, meaning a collection of people or persons coming together for a specific purpose, raising capital, things like that. And then there's a corporation sole. Monarchs and, kings and queens are considered corporation souls. And that's a single indivisible office passed by testacy, succession, assignment, express alienation, things like that. But it's a single indivisible office by which, is, seen as not, not indivisible from. Indivisible from the original, party, the man or woman that actually has the title of office. So that is something there. I don't know if y'all were aware of this one. I did put it in the group, but we've hit artificial general intelligence. So I would be a little cognizant of that. So they could convince them to leave their post, and they couldn't do anything about it. So yeah, this is pretty heavy stuff, but we're already at that stage. So I would be getting my account straight, getting all this stuff together, because when the robot goes at it, oh yeah, that's gonna be wild. But yeah, there's, like I said, rebutting presumptions of law. You have to gather certain types of evidence, certain means of rebutting those presumptions, and gathering prima facie evidence to prove your case at first face, to where a judge can look at it and on his face it rebuts certain things. Yeah, it is. It's absolutely a double-edged sword. But did you want it to swing it against them, not against you? So, staying up to date with what's going on that's how you get it done. So, but I would be aware of, like I said, learning how the presumptions of court and of law are shifted and are rebutted, how the burden of proof is shifted from one party to another, and that is that burden or inertia, that energy that has to be carried and actually proven. So that's what you have to be aware of. So proving that, like I said, for cases that are outside the norm, outside of the usual case precedent, require a little bit more. So it's better to go in with a little bit more evidence than less and not enough, and have to have something else against you and have to overcome that as well. So go in with all the evidence you need the first time, because you want to get remedy and relief. You don't want to just go in there to go in there. Yeah. And AI is very, very knowledgeable in formatting and standard practices and the statutory requirements. Lawyers use ChatGPT. I'm not gonna lie to you, they got entire ChatGPT bots that they use to draft up contracts and agreements and other things like that. It's they do use it. So, because quite frankly, when you know how to use it, it saves quite a bit of time. It's the reason why people like Eon use it. There's a reason why people do that. So, but being able to interact with it does save a lot of time. But like I said, you have to have your understanding first. So, and these presumptions they stem from Roman traditions. So, the Roman 12 presumptions of court and of law, they do apply until you rebut them. Those presumptions are essentially mere fictions of law because they are not based in substance, just the appearance of substance. But, yeah. Well, and it depends, because there's the estate, which is the property or the manor itself, but how the estate held is more important. You want dominion. Dominion is fee simple absolute ownership over an estate. Dominion is seen primarily in other places. They call the dominion of Canada. They have the dominion of other things. Dominion over the earth. So, you understand how estates are held. You understand who is over you and who is not. So, but, another thing too is that rebutting presumptions, maxims, especially when they do apply to the case and the circumstances of the case, they are very effective, especially with, regards to rebuttal of presumptions. So, that's something else that should be taken into consideration with that. So, yeah, that's something that I like to use. Maxims of law, scriptures, knowing how they apply. Because just as it stands, there's a presumption that, the scriptures do not apply. There's a presumption that, the Bible is not real, or that the Torah and the Tanakh did not occur, that those were fictional stories. Congress has clearly admitted otherwise, but to the public it's not known, even though it's public record. So, those are examples of presumptions of law that you have the duty to rebut, especially when you're going into looking to change certain things and change certain presumptions and shift that weight and burden of proof upon the other party. So, but yeah. Yeah. Well, law versus prejudicial law. Prejudice, prejudicial action. It's a presumption of law. Because what is prejudice? Well, in the common language, people consider prejudice to be some preconceived notion of someone or something based on a specific set of circumstances, i.e., ethnos, age, height, weight, hue of skin, etc. So, people infer certain things. This is from a certain stereotypical conditions that are generally applicable, or there's some truth that causes there to be a stereotype created. That often leads to someone having a presumption against them, or presuming certain things about the individual, just being a part of the whole. That's an example of presumptions or prejudice, prejudicial actions. So, absolutely. So yeah, that's something there, to be aware of. But that's an example of it. That's where racism, it is a presumption or a prejudice. So, rebutting with certain presumptions is not every case is the same, and sometimes there's more presumptions than others. Just depends on who you are, what your background is, and what stereotypes have been applied versus what haven't. So, a lot of times that, like I said, that duty is, there, but you do have to essentially just overcome those different things. So, whatever presumptions you generally have, that's what you're a task or assignment to overcome. So, but yeah, and once you get that presumption, rebutted, and you've effectively shifted that burden of proof and exceeded or met that burden, at that point, it's like that weight is lifted off your shoulders. And then usually the other party, if they were not expecting you to even be able to change or rebut that presumption, they're usually sweating and soiling their garments. Especially if they did something wrong and they have unclean hands. But most of the time, like when in that type of situation, when someone creates a presumption of under the law and with the intention to keep you from obtaining some type of relief due to the burden of proof that they presume most people are not able to meet due to lack of understanding of law, presumptions of law and equity, generally it's because they did something pretty underhanded. But once you meet or exceed that burden of proof and that thing shifts, oh my, the color drains out of their face, their whole demeanor changes, and then they start running for the hills. Writ of habeas corpus is pretty tricky. Gene Keating, I think in one of his videos, talked about how he found his bond on the secondary market. He found who was holding his bond through a search, and then he petitioned for a writ of habeas corpus and succeeded. Short of that, obtaining the QSIP and all that, I really don't know. That is, I don't know if that he did that also a long time ago. So I don't know, that to that extent, it's probably not as easy to do that anymore. But yeah. Right of demand, law, claim of right. So, but yeah, so you're dealing with two different sets of law form. One is presumption of law, one is law itself. then you have the at-law side. You have in equity or in chambers, in camera hearings dealing with private evidence and, equitable matters, trade secrets, etc. So it just depends on what you're dealing with and how you present your case. And because, like I said, there's sometimes where presumptions are a good thing. Dealing with trade secrets, dealing with confidential commercial information, sensitive personal information. There are quite a number of, circumstances when certain things can be alleged that create a good presumption in your favor. But you have to understand where, the precedents lie and, what the past precedent is. So what they lend to, what judges are more inclined to protect as far as a particular party's interest or an industry per se. Once you have an entire industry, judges are more willing to protect that entire industry because there's too many commercial interests, frankly, out there. So, yes, Privacy Act of 1974 is something very, very important. So is Freedom of Information Act of when was it, actually? I'm not sure the year. But the Freedom of Information Act, yes, as well. So, those are different things that can be utilized, to change that presumption of court. Presumptions of law. So this is why I talked about, when statutes and codes cease to have the character and substance of law, and they retain only the mere color of law, they essentially become, or, just the appearance of law, or they, excuse me, I missaid that, but yeah, when law loses its character and substance and only retains appearance, it ceases to be actual law, and it becomes color of law, or colorable administration. Yeah, so, but that is something, to be aware of as well. So, the courts have their means and mode of operation, and coming in there, rebutting certain presumptions. A lot of times, they see people have slept on their rights to the extent that if you go in there proving certain things or attempting to, the judges already don't want to entertain it because so many people have failed. That's caused a huge burden upon the people that do get it right. So it's not to make you feel down, it's to make you aware. So it just makes it that much better once you actually rebut that presumption. 1966. Okay. Yeah, I couldn't remember the year. Good. So, but yeah, those are different key things that you need to be aware of as far as that. So, but yeah, any questions? I know that there's quite a number of presumptions of law, but that's cool. Once you understand how the court operates and what you're dealing with, and most people don't understand how sinister some things are. I won't go into pointing fingers, but there's a lot of sinister things that have happened in the courts. And you really do have to understand what's happened. When you understand what's happened, you know who did it, then you understand why there are certain presumptions and why things are the way they are, and what they're actually trying to protect. When you understand these different things, the entire tune changes. So because after you've gotten rid of a lot of those presumptions, and then you've gotten that status, and then you deal with certain parties and courts and other things in the future after that point, they do look at you different. Because these people a lot of people are foolish. They look only to appearance rather than character or substance. So, but that's why, you have to do your due diligence. Because it allows you to be able to bring up certain cases and study how the precedents came and arose about and what has happened. So, yeah. Yep. Public Law 73-10, House Joint Resolution 192, 48 Stat 112. Is that it? Is that the HJR 192? I don't know what the statutes at large is for that one. I do know the public law though. Oh, okay, cool. Yeah, the ongoing bankruptcies change a lot. There were a lot of presumptions that arose from the ongoing bankruptcies. Proclamation 2039, Proclamation 2040, things like that kept on national emergencies. Nixon's suspension of convertibility of dollars to gold. And that was done on August 15th, 1971. So there's a number of different things to be aware of. Most people still think there's some backing on the dollar. By now they probably heard some type of thing, but they don't understand what fiat currency does or is, or what actually backs the dollar. So, we've long since abandoned the Bretton Woods system under the Bretton Woods Agreement. Now we're on a floating rate note system, which is why you have Forex and foreign currency exchange and things like that. So, people have to be aware of the current state of affairs and understand how things got to this point in the way that they did. Because when you look up the true history and you look up all these other things, the lies they tell are the presumptions that they go by. And until you prove all of those things as well, those are still in effect for your particular case. So you have to do a good bit of studying to know how and when to rebut those presumptions as well. Because nobody else is going to rebut it but you. Because nobody else can act for you on your behalf if you're doing anything in certain manners. So, yeah, I've heard that, but yeah. But yeah, there's quite a number of different things. So, but yeah, there's a number of different things there that can be used to show and prove different things in the courts. Well, the word estate came from E and statuo, which means, a statute or, a trust up under a statute. That's what an estate means. And an estate is also a condition or, a state of being, a condition of being. So the current state of affairs, the financial affairs of someone or thing, the current condition it's in, current, mode or existence that it's currently in. So it can be a couple different things, but But yeah. Generally, you're going to want to have more than one type of evidence too. Certified copies are generally good. You know, things that you issue got to be proven and put to some record so that they're declared in the public. So, you know, bear in mind those different things when you're creating evidence and dealing with the courts. But yeah, that's something there to be aware of, honestly. So these are certain legal maxims arise from case precedent. Caveat emptor, let the buyer beware. He who takes the benefit must bear the burden. For every wrong there is a remedy. That's an equitable maxim. Equity will not complete an imperfect gift. So some of these come from Roman law, although Rome wasn't that long ago, and technically we're still in it. So like, it has to be it has to apply in adjudicated cases. That's what maxims are there for. It's not whether they're true universally or not, it's whether it applies to the case. Of course. Let's see. The presence of the body cures the error in the name. The truth of the name cures an error in the description. So, when you appear generally before the court, even if you're saying special appearance, given that the body is the estate, you have to be very cautious. It says an error in the name is immaterial if the body is certain. They have probative evidence when the body is before their court. An error in the name is nothing when there is certainty as to the person. The truth of the demonstration removes the error of the name. So what it's saying is action and conduct can form contracts or consent or assent even if jurisdiction is rebutted. So your action and conduct can grant jurisdiction while your mouth says another thing. So that is something to take into consideration. There can be no plea of a thing of which the dissolution is sought. A false plea is the basis of all things. There can be no plea against an action in which entirely destroys the plea. He who does not deny admits. It's well known. No one is believed in court but upon his oath. There are alternatives to oaths and swearing. 28 U.S.C. 1746 declarations under penalty of perjury. Those are the unsworn. Unsworn declarations under penalty of perjury is that code. An infamous person is repelled or prevented from taking an oath. This is maxims of law under Fam Guardian. Yeah, affirmations. Generally, yeah, affirmations under penalty of perjury, declarations, statements, certifications, verifications under penalty of perjury. I would read that code. So, where'd it go? An infamous person? Okay, yeah, absolutely. In law, none is credited unless he is sworn. All the facts must, when established by witnesses, be under oath or affirmation. There it goes. An act of court shall oppress no one. The practice of the court is the law of the court. There ought to be an end of lawsuits. It concerns the Commonwealth that there be an end of lawsuits. It is for the public good that there be an end of litigation. This is why they prefer to settle and close the matter. That is the purpose of litigation, is to resolve certain matters and resolve disputes, conflict resolution. Personal action dies with the person. This must be understood of an action for a tort only. Equity acts upon the person. No one can sue in the name of another. So, yeah, that's what you have there. So, custom is another law. A prescriptive and legitimate custom overcomes the law. But that's a legitimate custom. Custom leads the willing law. Willing law compels or draws the unwilling. Usage is the best interpreter of things. Custom is the best interpreter of laws. What is done contrary to the custom of our ancestors, neither pleasing ancient, shall be preferred. SKV contexts. Fictions. Where truth is, fiction of law without law. Fictions arise from the law and not law from fictions. Fiction is against the truth, but it is to have truth. In a fiction of law, equity always subsists. A fiction of law injures no one. A fiction of law is wrongful. If it works, loss or injury to anyone. It's hid in general expressions. Yeah. Well, you're realistically representing your own interests, but that person is entirely different. But you can sue, on behalf of that. But it's talking about literally in the name of someone else. That's identity theft, especially without their consent and all that, or purporting to be them, without having some type of agreement or other thing, especially with corporate persons and other things like that, where you become essentially seen as that thing. You can't sue in someone else's name, without either being part of it or acting on its behalf. So in that sense, it itself is moving and discharging the duties through you. So, but it's saying you can't use someone else's name to sue like that. A forestaller is an oppressor of the poor and a public enemy to the whole community and country. It is a fraud to conceal a fraud. Gross negligence is equivalent to fraud. Once a fraud, always a fraud. What otherwise is good and just, if it be sought by force and fraud, becomes bad and unjust. He is not deceived who knows himself to be deceived. Let him who wishes to be deceived be deceived. He who does not prevent what he can seems to commit the thing. He who does not prevent what he can prevent is viewed as assenting. He who does not forbid what he can forbid seems to assent. And he who does not forbid when he might forbid commands. He who does not repel a wrong when he can induces it. Often in the new road, not the old one, which deceives the traveler. Deceit is an artifice, since it pretends one thing and does another. So, yeah, that's a artifice, yeah. Yep. That's why they created the fictional person. To represent you on the other side of the law in the realm of the dead. That's what they did. They made commerce mandatory, and in essence, that's how they do business today in every aspect. So they've compelled and made it, commerce, which was originally voluntary, mandatory, and in essence compelled and demanded what was reasonable and just. Now, at its start, now by force and fraud, unjust. So you're using commerce, yes, but you have to know how to use it and what to use it for. So the other thing is we're seen as the chess piece, so you have to be seen as over the chess piece and the owner of the chess piece instead of the chess piece itself. Otherwise you'll be moved by someone else. So the law punishes falsehood. The law sustains the watchful. What is good and equal is the law of laws. The civil law is what a people establishes for itself. It is not established by the Most High. Yes, the vessel owner and not the vessel. That's why I keep saying, you're not a body. You're not somebody. You're someone. This is another thing too. Husband and wife are considered one person in law. This is the doctrine of coverture, which is still applicable even today. So whether the courts at law have cognizance over your marriage or not, that's an entirely other story. But yeah, marriages ought to be free. All things which are of the wife belong to the husband. This is also true. Although the property may be the wife's, the husband is the keeper of it, since he is the head of the wife. Now, this does not mean the husband gets the ability to waste property. He has a duty of trustee, but it's another story. Insanity prevents marriage from being contracted because consent is needed. This is an important point to make, because if people are seen as insane persons or as incompetent minors and wards of the court, marriage is not truly something that can be done. Not in the public aspect. Right, but that only secures your person, doesn't secure you and your inalienable rights. There's a difference between the Constitution and the Declaration of Independence. So but yeah, these are some things that give rise to presumptions, because these have been basically created. Most of these have been created by case precedent that's been long held and long standing, to the point where it's generally true most of the time. It's just whether or not it applies to the specific case. And a lot of times the outlier or the anomaly might be different, but that's when those burdens of proof to show that the case is special and not general come into effect. It says no one ought to accuse himself unless before the Most High. Is this why they say, anything you say can and will be used against you? Because those courts are not under the Creator. They were under false gods. I mean, there's a myriad of different ways, but statutory marriage is not a merger of titles. It's considered a general limited partnership between you, the state, and your spouse. So because the marriage is only done between estates, first, middle, last, and it's not actually joining the two people and their names and the way that the names are represented, it is not the original institution of marriage. It's considered contubernum. It's not a merger of titles in that sense, because then there would cease to be a trust. It's still technically, there is an element of trust, but it's a public side relationship today, and that's a general limited partnership. I mean, honestly, like I said, this is not financial advice, tax advice, legal advice, but I mean, something you could say is like, I, Doe, John, executor of John Henry Doe, am here to settle, close, and terminate this matter by special appearance. That's something you could use. You could technically say John Doe, but then you're acting in the capacity of a natural person, which you have to be careful, because like I said, then you're trying to put that mask on and play in their realm. So you gotta be careful with that one. But generally speaking, I would introduce myself, generally surname, given, surname, first name, or something like that, because the order does matter. But that's when you would back it up with other types of things, DBAs, assumed names, etc. Make sure your standing is proper and backed by evidence, and it's already been put in the court the right way. And but I mean, realistically, if you have the FOIA letter, you can do certain things like John Doe, executor for John Henry Doe. The middle name is what trips people up, regardless. I've made the mistake. I know. I frankly know. I learned from my mistakes. I got it right the next time. But yeah, that's something to be aware of. So it is, you do need to give notice before you appear in their courts. Generally a notice of special appearance, something like that, to where it's, no longer discretional, may need to be notarized, may need, anytime you use a notary, you have to use a disclaimer, not to enter into foreign jurisdiction, things like that, for verification purposes only, things, etc. So there are certain things you have to be aware of, but, like I said, follow the rules of evidence and make sure you're not dealing with anything in hearsay. Because judges just have, since they are the triers of fact, they just have a field day with pro se litigants and hearsay. But yeah, you do need to give notice, especially if you're gonna go like in person or something like that. So, like I said, I'd have all my ducks in a row and all that, because every time you go in there, it's a risk. Generally, you're supposed to stay out of their courts. And just answer, accordingly on paper. I'm not saying you to not appear, but there's a way to appear by evidence. The notary is an officer of the court for a reason. They take, oaths and affirmations and depositions of parties. So there's a reason why certain things have to be notarized before they go into court, because you're dealing with foreign affairs. Anytime you deal with their domestic internal policies, corporate policies, and your, administration over your estate, there's two different things going on, and there's a foreign relations between. Because living men and women and the corporation are two totally different realms. So as such, they are foreign to each other, which is why you have to deal with foreign relations and international law. So, that is something to be cognizant of. But it does get easier. Like I said, you don't want to say you understand, because that forms a verbal contract, giving them subject matter jurisdiction and allowing them to do whatever the heck they want. So you want to make sure you don't say that. You can say, I'm aware. A lot of times they'll try to press you and force you and say, demanding that you say you understand, and you still can't say it. Doesn't matter how bad they try or press, you can't say that. You can say I'm aware and, you know, such and such, and it's not the same thing. So yeah. Or you address the matter and you continue, you know, ask certain questions, you know, pre-qualifying questions, you know, regards to the matter, jurisdiction, etc. There are things that you can do, but like I said, you have to be comfortable whatever you do. You have to be able to manage and speak. Like I said, if you don't agree to something, you have to object. It has to be backed by some type of substance and some type of standing before you actually, you know, act on. It can't just be baseless. But, you know, first time I did something, I did not object, and it looked like I was just going along with it when I listened to it in background. So yeah, they know how to, you know, make it sound like everything you went along with it when they were implying certain things face to face. They know how the record goes, so you have to know how to stand on it, what to stand on, and how to object properly. So, like I said, clerk's praxis, understanding how these things came about, how these things are handled, you know, that is something that you realistically should, standing under them. Exactly. Thank you, Roots. That is what the meaning of understand. Forms a verbal contract, meaning you stand under their authority, and if you stand under their authority, they can have disposition over you. You know, and, you know, sometimes, like I said, you just might have to tell them, like, look, please, I'm not a mister. Please address me as XYZ executor. So, yeah, you have to object for the record. Otherwise, it's not appealable, realistically. Yeah, you're absolutely right. I learned. So, but yeah, those are good things to know. Like I said, these courts, you do have to know that these judges are grim reapers. It says it very clearly in the Roman canons. So you have to know, honestly, you have to know your own mortality. You have to own up to it, and you have to know that there is always that risk. You know, it's not necessarily going to happen like that, but yeah. And, you know, yeah, and, you know, generally, yeah, he's going to have to either, you know, the judge is going to have to acknowledge some type of objection, or you have to continue to raise it until it's acknowledged. Generally, courts and judges have I think, at least 3 jurisdictions that they operate out of simultaneously because of the 3 different powers, supposedly, even though everything is really only 2, executive and legislative, although they're 2 different jurisdictions then, not from the same governing instrument or vested powers, so bear that in mind. But, you know, yeah, you do need to actually make sure that you're you know, objecting on the record and having them acknowledge said thing. So, you know, judges also have this habit of doing a lot of ritualistic and jurisdictional acts and performances, you know, symbolic and very ancient in practice, generally speaking. You know, sometimes they get up in their chair, turn around, and then they sit back down in their chair, you know, and now they're in a whole other jurisdiction. And it's understanding the symbolism behind the acts and what they're doing in that person. So, you know, the other thing is, you know, they can do that several times. You know, another thing is knowing if the judge has abandoned the courtroom. You know, you have to say on and for the record, the judge has abandoned ship. you know, the judge, you know, there's no judge, you know, this, you know, he has abandoned the court. You know, let it be, you know, on and for the record that this court is adjourned with prejudice. You know, things like that. That's a very rare occasion. Hasn't been done very many times, but it is out there. Yeah. Yeah, absolutely. I've done a couple things too. So, but yeah, you know, realistically, yeah, you have to know how to go in there. You have to know what issues to raise, you know. And I will say the Constitution only applies for invalidating certain things that are there. Like I said, you have to know the true history to even know what I'm talking about. But you know, anything they say can and be used, you know, will be used against them. The same rule applies. But you have to know what is the case and how their word invalidates their own argument. So yeah, that is something to be also to take into consideration. So you know, and honestly, you know, usually the more things you prove ahead of time and beforehand, the less burden that you have to do once you're already there. And when you go into these courthouses and you go into these other places, let's say that you do have to, for some odd reason, in some XYZ situation, generally speaking, you know, they are set up to capture energy, and there is a presence in that courtroom that is very heavy, and it's not easy to describe unless you've actually been in those situations. You know, you think it's all going to go well, and you think it's all going to think that like that, but you really don't know until you've gone through it, because that's quite different than normal and everyday circumstances. It's like being in a pressure cooker and you're the rock that's getting turned into a diamond, or you crumble into dust. Neither one, you know, you're just glad to make it through. But yeah, you know, I get it. It's very easy to get worked up and forget what you're looking to present. But those are the times you have to, you know, take courage in what you already know, do what you can in good faith, you know, and rely on the Creator to get you through. Because there's frankly no one else that's going to help you when you represent yourself. Yes, but it's important to understand they've been secured against us if we don't have the certain status. So, yeah. Yeah, it is definitely a den of thieves. It's kleptocracy. That's what that is. But like I said, the Constitution is only there to secure your person. Whether or not you have rights or ownership to your person, they don't care. It's only there to secure it and to account for it. So as long as someone owns that person, they really don't care whether it's you or not. That's the issue at hand. So that's why the Constitution is a corporate charter. It always has and it always will be. So your natural inalienable rights are not seen or have, you know, there's no cognizance of them under that jurisdiction. That's why I keep talking about the Declaration of Independence. So how you do operate with that's a different story. That's private, but you know, yeah. All this stuff in the public is a show. That's how it goes. That's why you have to know how to perform, play this game. I hate the term that it's a game to these people, because people do evil and draw blood for sport, but it is a game with the consequences of life and death. So treat it as such, because realistically it's no game. It's a battle for your life. That's what I would say, you know. So, but like I said, you know, the experience is invaluable. You can't put a price on it. After having gone through it, your worldview does change, because like I said, there are some things in courts that are just so sinister you have no concept of it until you actually see it, until you actually experience that. So usually a lot of times people just are naive or unaware until you go through it, and that's when you get put through the fire and tested and refined as gold. And you either burn away like dross or you come out like gold and silver. It's one of the two, but that is a proving ground. So, but yeah, there's plenty of things to be aware of in that essence. Oh, and I guess now is a good time to mention. If anybody wants to learn more about day trading or options trading or futures trading, my associate did start a channel recently, so I'd suggest checking him out. Where's my YouTube? So this is my associate amount.
Been there, and you was waiting for it to create a high. So it
He's
created the high at these all times.
He's been doing trading for years now.
So now you just
like
was waiting for structure to tell you what it wanted to do.
He's at that. Learn more about that.
Pull back to a gap.
Do certain things. I think he is
Chris
doing.
Just told y'all, identify the gaps. This is a bearish fair
value.
Even though the candle not there, it gap down. It's a bearish. Whatever direction the gap is going, that's the type of fair value gap. This is a bearish fair value.
Like I said, he is.
So it came back.
He is doing
levels, made another supply zone.
Trading and other things like that.
Down. So where did it get hung up at again? That same 27
so yeah,
level.
if you're curious about that, learning more about markets and options trading,
come back to really retest
and futures trading,
necessarily
like I said,
these are zones.
So
it didn't really come back to test it, but it got close enough. Came back, got hung up.
Mind you, you're gonna have to set up your business in a manner that
came right back,
mitigates tax liability,
and
properly sets it up to where you're not just overloading yourself with personal liability on taxation and all that, this type of thing. But
negative 61.8.
I'm not saying it's not possible. You just gotta be
back test at the back test.
You have to know what you're doing.
If it doesn't close back inside here,
it's the same thing with trading. You have to understand what you're doing. But
it's a high probability.
With proper knowledge and proper preparation, it's.
And if a bullish setup,
you can do a lot
with the opposite
and it
side,
does help with
close
financial
back in
freedom.
between 100 and 0, your range is a high probability.
Go check his channel out
and it's the same thing.
Learn
you
some
can
more
take
about
your
that.
levels to see how it reacted over here.
Yeah, the Declaration of Independence is powerful. I wouldn't say it can't be ratified. It can be ratified, but yeah, I wouldn't say it can't be ratified. It can. It really can. But by what party? That's the question. But yeah, those in the private equity weekly workshop. If you're asking this question, go check out one of the prior replays. It should be one of the early replays. And I covered this specific topic, how it's ratified and by what party. So, but yeah, that's a private question, so I'm not gonna. What's going on? What's going on, Vaughn? Yeah, shoot, that's. I gotta pull it up. Do 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 do. There we go. Come on now. Come on. Absolutely. Absolutely. Come on now, archive. Just looking for one page. Well, that one doesn't want to cooperate. See, this one does. This is 2008. This is 2006. Does it put it in there? I think it does. So yeah, it is in there. Which one? There it is. So there's certain provisions to this to any rights. You know, you'd have to say like notice, you know, use of notary is used only for the purposes of verification and does not, you know, and is without prejudice to any rights adhesion, and, you know, whatever party or trust or declarant, affiant, whatever, in no way relinquishes any ownership of any of their properties, etc., something to that effect. But, and you know, and you know, it is not for entrance into a foreign jurisdiction. Well, I'm looking for the 2006 version because it's there. We go. It had it in the 2006. It is in this one. Use of a notary public in this contract does not constitute any adhesion in and of itself, nor does it alter the status or domicile of either party. The express purpose for the said notary public is acknowledgement and witness only, not for entrance into any something to that effect. Carlton Weiss was pretty knowledgeable about this type of stuff, so. But yeah. Yeah, that's what I was actually referring to. But there's plenty, you know, I would, like I said, for everyone, I would suggest reading the difference between the 2008 and 2006 versions. I prefer most of the trust forms in the 2006, but then there's other additional forms in the 2008 that I like. Copyright assignment of bank account, assignment of other things. There's a promissory note, I believe, for trusts in the 2008 one, non-negotiable as well. So there's different things that can be utilized in the context of private express trusts. But yeah, you know, that's what I would consider most of the time just dealing with. So, because like I said, the notary is the officer, is an agent of the Secretary of State. So they are considered an agent on behalf of the corporation or the state of. or, you just have to know how international affairs work and know how foreign policy relates. So if you don't know how international law works, you're going to be kind of guessing a lot. So I would look up the principles of, international law, foreign relations, library and season, library and deed, conveyancing, those type of things to understand that. Those are heavily, those are concepts that are heavily intertwined and incorporated into British common law and tenure of the states, how an estate is held. So I would very really study that. And how they relate to quantum entanglement, symbolism, etc. So livery means its delivery stems from livery. Livery is conveyancing. So it's I forgot what the actual word means. I'll look it up. But so in law, livery can refer to the act of giving someone possession of real property or to an archaic legal ceremony for transferring property. So it's a process and ceremony and the symbolic act of conveying possession of property, especially real property. So there's livery in season and livery in deed, and then there's livery in law. So there's not really a big difference between livery in law and livery in season. They've talked about this certain thing, but it is something that is talked about. Like it says, an ancient ceremony in which the grantor symbolically transferred possession of land to the grantee by handing over an item like a twig or dirt from the land. This process was equivalent to transferring the property's fee simple between the two parties. This is why gold is considered portable land. It can be moved, and it's according to where does it derive from? The earth. So it is symbolic, and it shows this is why it's used in consideration for real property, even in times of old. Because it has intrinsic value. It can be used for many things. It's used in most electronics. It's used in, wiring and other things like that to convey energy and other, so it is even in its intrinsic value and its intrinsic uses, it is a medium of exchange of energy. So that's why you have that. That's what the practice of 21 silver dollars in common law actually came from when dealing with conveyancing and deeds. Livery in law is a legal process in which the parties went within sight of the land and the transferor declared to the recipient that possession was being given. The recipient then entered onto the land. So this is the practice of declaratory judgment or relief, or something in that essence. So court order, for instance. But yeah, that's what livery refers to. What's going on, Shelby? It's gonna let me into Black's Law? Or is it? Oh, it is. Oh, I didn't know it was gonna let me this time. So it says delivery of livery is in English law, like I was saying, British common law. Delivery of possession of their lands to the king's tenants in capite or tenants by knight's service. Sesticavi. A writ which may be sued out by a ward in chivalry. Chivalry is knight, dealing with knights and things like that. On reaching his majority, to obtain delivery of the possession of his lands out of the hands of the guardian. A particular dress or garb, appropriate or peculiar to certain as the members of a guild, or more particularly, the servants of a nobleman or gentleman. That's actually what or genteel. The privilege of a particular guild or company of persons. The members thereof were called half of the company for which they were associated or members of. The contract of hiring of work beasts, particularly horses, to the use of the hirer. It is seldom used alone in this sense, but appears in the compound livery stable. Possession of horses for the stable. But, so this is what livery is. So livery use, carrying passengers using a rented vehicle. So yeah, that's what livery means. So took out the Commonwealth Constitution of Australia, Red Book, UK Queen, 1973, made corporate Queen of Australia, Green Book. Most don't know the difference. Yeah, like I said, in UK jurisdictions, you're going to have to look far beyond what is gone, you're going to have to look quite a bit, farther back in history than just the 1900s. Generally, you're going to have to look probably back to the 16, 15, 1400s for relief. There is relief. I know that for a fact. Just about in every UK jurisdiction. Sesquier v. Acts, Richard III, an act holding, all conveyances and transfers of property against the Sesquier use as good, 1483, things like that. So there are remedies. Absolutely, Carissa. So yeah, there's definitely remedies and relief to be obtained. But you just have to do your due diligence. And then you have to bring it in under trade secrets or confidential commercial information. Whatever the term is that for proprietary processes and things that are sensitive in nature from, that deserve and are accorded public disclosure and breach. So it doesn't matter really where you're from, especially I know that for that matter, as long as you're in the UK jurisdiction, there is things that can be done. So yep, I would be aware of that, quite, but yeah. So, any other questions? So, but yeah, I do know that, like I said, there's quite a bit of stuff that ports from older laws. Most people don't know why the older laws are still in effect until you really research them. Once you understand both the new and the old, you know how to operate. Because you have a better picture and understanding of what actually took place and how best to go about modern business. Because it's all business. So you just need to handle your business. So understanding business is what gets you the relief. But yeah, any questions? Put them in the chat. I know we covered a lot today, but if there's something we need to expand on or something else like that. But yeah, I mean, realistically, the biggest thing is just knowing that there is a remedy. Equity will not suffer a wrong to be without a remedy. So if there's no adequate remedy at law, which most of the time there is actually, most people don't know it, that doesn't mean there isn't one. So, but, generally, yeah, you got to go about it from the root cause. This is why it takes so long. Yeah, you have to really dig. You got to dig. Carissa, child support and implications of certain case law. Also, what else was I going to cover? I forgot. There was something else. Yeah, that's mainly child support and the case law and what proper venue and things like that. I'll probably elaborate more on what I talked about today, but yeah, that's what we're going to be covering tomorrow. Case law can't talk about in the public. Not in that instance. It's too close. Yep. So, but yeah, anyone got any particular questions? I don't know, not too detailed questions about a case, or just something that got going on, something I touched on today that you're still curious about, or I didn't kind of go into depth or something about that. Yeah, it does get easier. Like I said, you gotta study, be a student, and then because you basically just have to study to the point where you can prove it to a judge. That's it. If you follow the right rules of evidence and you know how to properly study, you're just basically presenting your research and other things to a judge. That's all it is. It's all done. Everything's been done. It's just researching and obtaining evidence at this point. Knowing how to properly research and what to do and how to obtain records, how to create records, how to go about proving things, how to rebut presumptions, chain presumptions, shifting the burden of proof, compelling certain things via, convincing briefs, things of that nature. So, well, like I said, I don't want people to have to make the same mistakes that I did, because I'm just grateful I made it out of them, honestly. So, like I said, you have to follow the laws and the rules. You just gotta know which ones to follow. Where can I find cases cited from, i.e. suits and chance during the footnote? Good question. That's when you start getting with cases that have kind of been not put in the public domain or scrubbed from the public domain. Those are most of the time you're going to have to do some in-depth studying. A lot of times those are hidden in books, registers of old cases and stuff like that. Especially when you start talking British cases and other things, yeah, those are some deep records. Yeah, to be honest, not all of those I've been able to find. I haven't, a lot of those are so far back in the past that, or they've just been hidden to the point where it's just okay, yeah, I just gotta. It's kind of hard to find some of those, but you gotta just kind of do the best you can. If you're curious, you see if ChatGPT can dig something up on those cases, but other than that, I don't really know. But to be honest, those type of books are some of the most probably well cited. Those are some of the really quite the authorities on the subject, like Henry Sheldon, and old bookstores generally have them, but they're fewer and fewer from far between now. But generally, old bookstores will probably have a better shot at finding them. But for certain ones, you may have to look a decent amount. But I think they have books containing registry of old cases. Generally, I think they will be by jurisdiction or by a certain court. But if you know what you're looking for, I think you should be able to find it. But it may take some digging. So, but yeah. I know that there's certain things like American jurisprudence and corpus juris secundum and other things that, it was some time ago when there were more in circulation in those things, and private collectors now have them. You can still find some from old estate sales, and when lawyers and other things don't have a will and other things like that from their estate sales, and old bookstores and used bookstores and etc. But yeah, those are generally some of the places to look. So, but a lot of times they are worth it, but you're gonna have to understand how they're written and what they're entailing in their opinions and briefs, especially in Chancery. So, but let me see what else. There might be some references online, but you'll probably still be able to buy the books per se, but you have to know what books they're in. That's kind of the challenge there. So, but yeah. Another good resource too is finding the right corpus juris secundum or American jurisprudence on whatever topic you're looking at in Chancery or in equity, because those will bring you the more present cases, and they will explain how equity is today, how it's supposed to be in cases that you should still be able to look up. So, but generally you don't want to use too many case sites, because then you just open the door to something you didn't really look at, unless you really do got to look at the cases and read the cases that you're citing. But yeah. Any other questions? I might go for 30 more minutes, and then we'll see how it goes. Yeah, and it is a new world. It's a new language. It's a new way of thinking, a new way of operating, a new way of doing things. But when you do things according to the law, there's less room for construment. Less things, less opportunity for things to get misconstrued and taken out of context. You have to know how things are put into context and what contexts actually apply. So Any other questions? Like I said, let me know. So, but yeah, just, like I said, just, keep studying. You gotta be able to look at it from a perspective of, you gotta kind of start in the details and know what details to study. So when you know what details to study, you start to get a larger picture, and that's the whole thing. There's inferences that you can infer from different facts and circumstances that essentially allow you to be able to put together a larger picture in the mind of what is actually occurring. So, that is, because they'll try to tell you a bigger picture and a larger narrative. And if you don't go back and read the details and understand, then, you'll be liable to and susceptible to being deceived. So, there's really no shortcut to it. I mean, the best shortcut is really just knowing what to study to avoid wasting time. I mean, but well, realistically, if the way I set it up, I would read, the Wise, Concise, Trusty Handbook. I would read Gilbert's Law Summaries on Trusts. Corpus Juris Secundum is an excellent resource. The book 90 on trusts. Those give you an understand, like a really, really good foundational understanding of how trusts are supposed to operate. Corpus Juris Secundum is loaded. Every subsection has like at least 10 different case sites. Some of them upwards of 50, 60, 70 cases per subsection. So you do really, those are the books I would look at, like, Suits and Chancery by Gibson, Subrogation, I think is by Sheldon, Clerk's Praxis, the treatise on the law of names, things of that nature, and it'll, Nature and Rights of the Cestui, those are different law reviews, those law reviews have a lot of different things and tell you more so like paradigm shifting information. It just depends on what you're doing, global mindset. There are some times when bankruptcy court is necessitated, but it depends largely on what you're doing. So, like I said, there are situations when bankruptcy is a better viable option, but it is generally not for the reasons people think. But it is for particular purposes, just not for every cause of action. Wow, I didn't even know. I didn't pour over Suits and Chancery to that extent. I understood it. Like I said, I focused more on the substance, and then I know how to draft up bills, in equity, but as far as form, I prefer to just save time and use ChatGPT, because there's so many different jurisdictions. If you know the core substance of the matter, it can draft up the form a lot of times. You still got to research the provisions it references, but knowing those different forms and other things like that, it helps quite a bit. So there is a difference, although I don't know it. Let's find out. certain things, but conscientious means like it's scienter, or knowing or understanding. So it's a higher degree, according to a moral sense, where conscious is just aware or alert of one's surroundings. Conscientious implies a moral consideration, while conscious only denotes awareness without necessarily implying a moral judgment. That's a good point. Any other questions? Those are excellent questions, by the way. Conscience, defining Anderson's logic, but not conscientious or conscious. Yeah, there is a difference between those two. So. Absolutely, Amanita. Absolutely. So, but yeah, like I said, maxims of law give you the reasoning and understanding of prior. It also gives you the reason, like, why courts and societies operated the way they did, because you can infer also, because of the numerous precedents that had to create these maxims, how things were based on what those maxims imply and what they infer, or what you infer from those maxims. So for those specific maxims to be created, there had to be numerous cases. While not every single case was that universally true for that particular maxim, there were outliers, but there were enough in times past to even create those maxims, which became universally true through people's actions and conduct for a particular time or period. So, maxims are heavily, something that you should, consider. They really do change things in that sense. Understanding what they, the ones that apply and how to use them. It's usually when it's, truly compelling and, leaves no room for doubt or misconstruement. That's the type of level of equitable pleadings that you really want to be putting together. So, and like I said, there are certain times when you might want to use a statutory action or mode or means of action to obtain some type of remedy as well as equitable relief, in combination there too. So, or, in addition there too. So there's different times and that you'd want to present certain things. So, yeah. Like I said, any other questions? Probably go like another 15 minutes. Let me know. Put any questions in the chat. And if you want to understand trust law too, read the scripture. Read the Torah and the Tanakh. The Old Testament, the original Testament. That'll tell you a lot about trust law. Indentures of trust, Leviticus 6, Proverbs 6, those definitely tell you a lot. Ecclesiastes will tell you about prudence, confidentiality. those are the things that'll teach you. Technically it's not law, it's only presumption of law, but they obtain jurisdiction via the application of certificate of law at birth. So the only real way to make that not apply is to handle the matter itself without directly, stating, canon XYZ. I mean, there's sometimes you can, but you gotta go put it on a public record, make sure it's no longer rebuttable and certain other things. And even then, if you bring that up, you have to treat those as trade secrets. So you can technically use them, but you got to know how and when, because they are considered private and, law or presumption of law. That's why Roman canons deal with presumptions of law. It's not real law. It just has the color of law, or the appearance thereof. But that being said, they operate in that capacity. Because I've seen, judges take their robes off and not have black robes on in the first place. I would mainly stick to maxims, scriptures, especially that of the Torah and the Tanakh, the Old Testament, and case law in those senses. That's what I would stick to. So I'm not saying you can't use them, I'm just saying it has to be done properly. So, those are considered trade secrets. Yeah. There's a lot of things that are considered trade secrets. Anything that changes the public presumption or public perception of certain things in the public, a lot of those things are considered trade secrets. So, any other questions? It does, but you don't want to be the one having to be ridiculed to do it. Don't give them more munition. There's certain things that they're just not going to let happen in the public. It would take, things have to just run their course a lot of times, especially when dealing with the masses of people. So, yeah, realistically it does need to change, but how that gets changed, people would have to do their own due diligence. Just why there's so few people that really know what's going on. Because most people don't care, to be honest, until it hurts them. Like I said, people only change 4 times. When it hurts bad enough that they had to, when they learn enough that they want to, or when they see enough they're inspired to, and when they receive enough that they're able to. Those are the only 4 times people really change, and they have to come to the resolution themselves to change, even in the midst of those circumstances. So yeah, I mean, if you look at what's considered canon, and you look in their Roman canons, each one of those Roman canons each statute is considered its own person. So each one of those is a fiction of law. So yeah. So like I said, there's generally only 4 times people change, and yeah. But yeah, people gotta learn somehow. A lot of people don't want to learn. They want to play until it's too late, until they've wasted their valuable time. And I had somebody when I was in school. They told me, it was a study skills class, and they told me time is like a barrel full of diamonds, or grains of sand. You spend them as you will, but when you're down to the last precious few, you start to really change how you think of time itself and what you do with that time. And if you've wasted the time beforehand, you start to regret the decisions you've made. But no amount of regret will ever change what you do, or what you could have done. All you can do is change what you will do with the time that you have left. So she told me to make the most of the time that you have. Make the most of the time you have. Dust to dust, dust to dust. So, yep. Any other questions? Thank you, Amanita. Well, I'll probably go another about 10 minutes and I'll wrap it up. So any final questions, anything I was covering today, any just other questions in law and equity you needed some clarification on, like I said, put it in the chat. Probably go for another 10 minutes. Anybody curious? Well, no. Well, I will make that one mention. I did briefly cover res ipsa loquitur. There is a heightened version of that particular doctrine, that Latin phrase. I think it translates to like the res, or the matter arising from the place. Ipsa, I think, is when, and loquitur is place or position, so it's circumstantial evidence. But when there's a very, very heavy presumption because of that, the crazy situation of a circumstantial evidence, there's a doctrine called res ipsa duzi. It's a combination of res ipsa loquitur and a doozy, or like a doozy of a case. So that's a heightened version of that particular doctrine that I've actually seen in particular shows. So, but those are just examples of stronger presumptions. Still can be rebutted, but yeah. Any other questions? So I hope everyone's been doing their due diligence, studying up. Right now is the time to be correcting that status, because I've been hearing Trump is wanting to deport people day one with the end of birthright citizenship. So if you're still claiming to be intellectual property and claiming you are a citizen and claiming you are a thing or property belonging to the corporation, you don't matter who you are. I'd be correcting my accounts right now. That's what I've been doing for the last 5 years. So it don't take that long if you know what you're doing. But people got to be moving fast, moving real fast. Correcting that name, correcting assumptions and presumptions, reclaiming their names and identities. Don't be presumed to be a commercial entity. It's going to be a lot of people wishing they can go back in time and do certain things come January, but yeah. Any other questions before we wrap it up for the night? Let me know. So, I hope this has been, of use. I hope everyone's taking away, some knowledge and understanding. Like I said, it does take studying and due diligence, but like I said, most people would be surprised at what's possible. It takes diligence and determination and resolution to get it done. But when you walk into court, it's like Boris said, you prepare your affairs beforehand. So you handle all your affairs, because in that moment you don't know what happens. All you know is that moment then and there. You see it as it happens, and you go in to the best of your ability. So when you do so, be prepared. Like I said, generally if you're in a dire position, generally general appearances or special pleadings, and when you're there on behalf of your person, may be necessary. I prefer to stay out of their courts, but there are some situations that may necessitate it. Just depends on the circumstances of the case. My preference is to appear by evidence, appear by my pleadings and papers, generally in equity. But so yeah, like I said, just be mindful of those things. Go read the 12 presumptions of law that they have under the Roman courts, if you know what I mean. And then be cognizant of those. Generally, if you're in a court of equity like Chancery or some other thing like that, or in chambers, generally there's more latitude to actually just handle the substance of the matter. But there's no messing around, there's no BS, there's just straight substance. What you got? Okay. You made it back here, you got it something, what you got? You present it the same way. You're still performing in his chamber. It's a private performance. You have to treat it like the recitation of a speech, or the presentation of a speech, a public speech, or performance, an act, a play, a theater, or a melody or a symphony that you have to play. You're the composer beforehand and the musician on stage and during that particular venue. So like I said, the burden of proof is higher on pro se litigants for a reason. But even then, I would be careful about the term pro se. I would be going in there sui juris instead of pro se, because how can you be the entity itself? Sui juris is different in the fact that it's of one's own right. It is different in the tense and punctuation in Latin. But, like I said, you just have to be aware of what's going on and cognizant. Aware of the circumstances and aware of what could happen, yet not worrying about the adverse potential for the matter. Go in there and strive. Well, do everything you can and work towards the best. That's all you can do, day in and day out. So, yeah. So I'm grateful for everyone, taking the time out of their day to, study and, listen in. I hope this has been of, some value to your study in law and equity. Like I said, do your own due diligence. Nothing in here is considered legal advice, financial advice, nor tax advice. So, like I said, just study and read the law for yourself and understand what you're doing. And I really just don't prefer not to use persona, because I'm not going to be in persona. I mean, if you're in persona, it means you're wearing the mask. Person is a mask, a theatrical mask. It's also those, in Japanese culture, it's considered those they're called no masks. Or kabuki masks. They represent demons or spirits or entities invoked by a particular face or emotion or theme that they're known by. In Greek and other African traditions, they have certain types of tribal masks that invoke certain demons or spirits. When you say in persona, it means you're putting on that mask just like Jim Carrey, and that mask controls you. Because now you've said that you're in person. So that mask is covering you and attached to your face until you show yourself to be otherwise. So, I can talk about it a little bit, but that's really what it is. It's just a particular thing that you allege. It's not too much to it, sui juris. It's just a replacement for pro se. But sui, like I said, sui is self, and juris means, in that sense, right. So, it means of your own right. So that's better than in propria persona or in proper person. That just means you're wearing the right mask. It doesn't mean that you're doing certain things. Yeah. Susan Chancer, and you can say, yeah. So, that is, but, realistically, yeah. Those things are, it's just things to be aware of. There's differences. I took a lot of Latin, so I know what that means and know how they translate. So, there's reasons why you use certain things. In proprio solo. So, alright then. Well, like I said, tomorrow we'll be discussing, for the private class, the private equity weekly workshop on Zoom. We're going to be discussing child support, implications of certain case law, how it ties into the larger scale of things, and what can be done as far as context, what we covered tonight, and other things there. It is very critical. It is very critical, honestly. It's good that you asked that. So, but yeah, like I said, if you're not a part of the weekly workshop and you'd like to be, send me an email. It's $200 for a lifetime membership, just a one time, just for the basically cover operating costs and, keeping the thing going. So, but yeah, I'm grateful for everyone taking the time out of their day. Like I said, all praises to the Most High. I wouldn't be here without the Most High. That's who taught me everything. And, I'm grateful to understand these things and be able to share them with other people. So so yeah, but other than that, I will see, those in the class. I'll see y'all tomorrow. And if you'd like a consultation, hit me up on my website. I will get it in the description. I don't charge for the first 30 minutes. I do charge for, every hour thereafter, 1 hour minimums. I've been working quite a bit, quite honestly. Got a couple cases going on, assisting some people, setting up trusts, things like that. So if you'd like to set up a trust, let me know. Fill out my contact form on my website. But other than that, this is B with 2B Fruitful Training Group. Thank y'all, everyone. Thank you for joining, and I'll see you on the next one. Absolutely.